Well, good morning, everyone. Today we have a member of our advisory network, Sandip Soli. He is going to be talking about pitfalls and traps you may find when you're entering into or extending your property leases. Um, Sandip is a member of our advisory network, which means as a member, you get a 30-minute consultation complimentary a year. So if you are interested in talking to Sandip later on after this webinar, reach out to your territory manager and they can put you in touch with him. We are recording today's webinar. It'll be up on our website and our YouTube channel and our podcast channel later on this afternoon, along with the slideshow. So if you want to go back and refer to this, you are certainly welcome to do so. And if you have any questions during the presentation, go ahead and pop them into the Q&A at the bottom of your screen, and we will answer those live on air. Don't bother to wait until after the presentation. We will go ahead and ask questions while he's giving his presentation. So let's get this started. Good morning, Sandip.
Good morning. Thank you. Again, this is Sandip Soli. I'm a commercial real estate attorney based in Seattle at a law firm called Real Property Law Group. We've been around since 2001. We have 6 attorneys on staff and paralegals. We've represented clients all across the country, some notable ones, including Nordstrom and some regional restaurant chains, as well as some landlords. So we see the other side of it as well. And so hopefully, with our experience on both representing tenants and representing building owners or shopping center owners, we can help you get to some middle ground with your landlords on how to enter into or extend an existing commercial real estate lease for your restaurant or some other property that you might have. Maybe it's an office, maybe it's even a hotel. We've done ground leasing for hotels as well. And we want to keep this interactive, as mentioned. I just don't want to drone on. Certainly, if you've got a burning question on a topic, please go ahead and ask in the Q&A, and we can interrupt and address the question immediately as opposed to at the end. But certainly, there's time at the end where we can answer questions. Before I get started, here's my contact information. I'm currently in downtown Seattle, but as mentioned, I've got law partners in other parts of the country, and happy to communicate with you wherever you are. Here's a roadmap of what we'll be talking about. We only have about 50 minutes or so, and each one of these topics we could go on for many minutes, but I'll try to do an overview. And if you've got a question that's more specific, we can certainly dive into that question. We're going to cover the key lease provisions today, so not an entire lease. And in it, some leases can be 80 to 100 pages long, some can be simpler and shorter, but these are the main provisions that we typically talk about when we enter into a new lease, and sometimes when we extend leases as well. Although with renewals or extensions, you're often just talking about rent, and everything else typically remains the same. So base rent, we'll be going into what constitutes base rent and other ways to compute rent, including what we call triple net costs or operating expenses. We'll also talk about percentage rent. I mentioned operating costs, real estate taxes, your security deposit that most landlords require, unless you're probably a national presence, then you may get out of a security deposit possibly. Utilities and tenant improvement allowance to help you build out your restaurant or other space. So I will start first with rent. Base rent, I think most of us know what rent is, whether we've rented an apartment or have been leasing restaurant space or other space for some time. This is your minimum rent that you're paying. This is the fixed rent that may increase over time, either with a 3% bump, or maybe it's pre-negotiated what those bumps are annually, or maybe it's subject to some sort of CPI index. But the basis of payment is typically due on the first of the month. Sometimes for some restaurant clients, we've been able to negotiate a grace period of 5 to 10 days until all the money comes in from the prior month. And you're able to pay, all your other expenses and then pay rent. Not too many landlords are welcoming. Typically, they have their mortgages due on the first of the month, so they want their rent paid into their bank account on the first of the month so they can pay their mortgage, taxes, and other things, insurance as well. So it's not usual that we can get a grace period, but sometimes we can. Adjustments and offsets. Sometimes there will be offsets to the rent that you have to pay. For example, maybe you've overpaid in a prior year operating expenses, and there was a reconciliation from your landlord that came back and showed that you've overpaid and you should get some credit. Sometimes you can get credit against the rent that's next due. Sometimes it's only against the operating expenses that's next due. It's all a matter of negotiation as to what you can get in the lease language to get that offset, which can be very valuable sometimes. We've seen during the pandemic and during off years that operating expenses that landlords budgeted actually went down when building occupancy was lower than in past years. And so there have been credits that have come to tenants when operating expenses are actually below budget and you get a credit for what you've overpaid to the landlord. Sometimes that's not always the case. Sometimes the landlord comes back to you with a bill showing that their building expenses were actually beyond the budget that they expected and they're asking you to pay more. That's a problem. And hopefully, we can negotiate some sort of grace period or some sort of payment plan, or maybe some cutoff that they can only come after you for the prior year, but hopefully not, several prior years to that when they found out that they didn't bill you enough. Taxes and penalties. Typically, we see 5% penalties if you don't pay rent on time. And in addition to the 5% late charge, we often see a 1% per month interest rate, which is the default in Washington. Sometimes you can negotiate a lower interest rate with the landlord if you're late on rent, but since the default in Washington is 12%, which is probably the highest I've seen all over the country, a lot of landlords stick to that, saying, well, if we didn't even talk about interest in our lease, you'd be paying 1% per month under Washington law. So why would we go any lower than that? So that's something that's up for negotiation as well. But, you kind of have to pick your battles, and hopefully you're not negotiating too many of these penalties or interest issues, because then the landlord will probably question whether or not you can pay rent on time. But it is something to negotiate. When you negotiate a lease, that's really the only time you can raise these issues, because once you sign it, it's kind of set in stone and you're stuck with what you've negotiated. The next provision we often see in especially restaurant leasing is percentage rent. I see a question. I'll get to that next when we talk about operating expenses. Percentage rent, you may or may not have this in some of your leases, but a lot of landlords and restaurants do enter into leases that have percentage rent. We saw a lot of this happen during the pandemic when restaurants couldn't pay the base rent, and in lieu of the base rent, they would pay percentage rent for a short term. And then in good times, we often see percentage rent added on top of the base rent that you would pay. Typically, we want a break point. We don't want percentage rent right off the bat. We want to hit some break point number. Sometimes it can be low as the base rent number that you're paying per year to the landlord. So you're paying the greater of basically base rent or percentage rent. But oftentimes it's a formula, what we call the natural break point. And I don't know what's natural about it other than there's a formula. So oftentimes, if, for example, if your percentage rent is 6%, what you'll do is you'll take the annual base rent and you'll divide it by 6% or whatever percentage you have to get to that number. And that is the break point. And only when you reach that break point in gross sales will you have to pay percentage rent, which typically is more at the latter half of the year for most restaurants, closer to the holidays. That's typically what I see. In terms of due dates, typically we have reporting from the tenant to the landlord every month. Maybe it's just a matter of forwarding your retail sales reporting that you often do with the state of Washington monthly, and you just forward that or something similar to that report to the landlord to provide them documentation of what your gross sales were. And then you would pay a percentage rent on that if you've reached a break point at that point. In the lease itself, we'll often define what gross sales are, and we may have exclusions, for example, for service charges, tips, gratuities, credit card charges, things that are that the restaurant's actually not taking in, but actually paying out to others. We'll try to exclude. Gift cards or gift certificates sometimes are debatable. Are you getting money in when you sell the gift card or gift certificate, or is that just money in trust held for later for when the customer actually spends the money at a, maybe at a different location, maybe it's not at this location. So that's something that gets debated in lease negotiations. We talked about tenant reporting. Typically it's monthly, and typically it's some form of what you've already been providing to the state of Washington for your sales taxes. In terms of audit rights, the landlord will want at least the lease language to reflect that they have an opportunity to audit your books if they don't believe that you have been accurately reporting your gross sales. Hopefully, if you're just giving them exactly what you're giving the state of Washington, it shouldn't be an issue.
All right, are you ready for your question?
Yeah, I see the question here. I'm just
Is there anything I can do when the global landlord hires a property management firm whose expenses have doubled from the previous property management firm? My CAMs have doubled as a consequence.
Yeah, good question. So when you're talking about CAMs, you're talking about common area maintenance expenses, which often is referred to as operating costs or operating expenses in a lease. So yeah, typically you would have, if you've negotiated this in your lease, audit rights to be able to look at the landlord's books and records to see what happened. What I have seen when I see this from tenant clients, is that a new landlord or a new property management company comes in and decides, oh, there's things that we could have billed that we didn't bill. Why didn't we, let's just bill it all through and frankly see what happens. And I will often look at the lease and I will look at the tenant audit rights in the lease and see, what can we ask for? How far can we go back in asking for books and records from the landlord to confirm that what they're billing through is legitimate or not. So a lot of these audit right provisions may limit you to only the prior year. Typically, we try to not have that limit because maybe they tried to bill in more than the prior year, which does happen. I mean, I've had landlord clients that fail to bill all the utilities through as they should have, and all of a sudden they're billing a tenant, 3 years worth of utilities that they failed to provide. But it all depends on the language of the lease. If there was some cutoff in the lease that you can only go a year back, then you can only go a year back. But if there isn't a cutoff, then it's somewhat debatable because the statute of limitations is much longer, typically 6 years on a written contract. And so they conceivably could go back. And often there's language in a lease that says the landlord hasn't waived their rights to seek payment for obligations that, they failed to bill, frankly, earlier, which is, very unfair to the tenant who gets blindsided by a bill that basically doubles the CAM charges, as the question says here. So hopefully there are audit rights where you can go in and ask for an inspection or copies of the landlord's books and records so you can actually confirm that those charges were legitimate or not. I've got a lot of clients that do that either directly with their property managers in-house or with accountants, outside accountants. And sometimes there's some folks that will do it on a contingency fee basis. A lot of leases try to avoid that. Landlords don't like The accountants that do that on a contingency fee basis, they get a percentage of the savings that they get when they audit the landlord's books. So you have to be careful about that language. You also have to be careful about language in leases that require you to hire a big three accounting firm to do it, because that's going to be way too expensive. And that's basically a disincentive to actually auditing the landlord's books. So you have to be really careful about that language in your lease. Finally, if you don't have the audit language in your lease and the landlord is not cooperating and providing transparency in their books that show these charges and whether or not they're legitimate or not, then I suppose you could litigate. It's sort of the nuclear option, but you do have a right to, seek out that information if they're not being cooperative. And if you have a reasonable basis to believe that they're charging things through that shouldn't be charged, then you could litigate in court. Or if there's an arbitration clause in your lease, you could arbitrate and find out if that information is legitimate or not. Hopefully I've answered your question. Happy to talk in further length. I think I've pretty much exhausted that one though. I've got another question here. It says, do you typically see audit rights in a lease that doesn't have a percentage rent clause? The answer to that question is yes. Yeah, all the time. I do see that. I don't know. And I think you're talking about landlords' audit rights, because why would the landlord need to see the books of a tenant when they are not providing percentage rent, when gross sales really shouldn't matter for a landlord because they're not paying percentage rent? So why would the landlord need to audit the tenant's books? The typical response we get from landlords in shopping centers is that they want to know the data. Maybe they want to know the data primarily for seeing how healthy their shopping center is, whether it's a strip mall or a shopping mall or a mixed-use building. They want to know how healthy the tenants are, and that helps them, they say, in financing. It helps them if they go to sell the building to show in gross numbers, what kind of sales this building generates. That's typically what landlords will say they need those audit rights for. The other reason also is to know how healthy their tenants are in terms of their business and how likely or unlikely it is they will stay in business and continue to pay rent. And another reason is, how creditworthy their tenants are. So those are the type of reasons we usually hear from our landlords as to why they need to have audit rights and continue to get financial statements from tenants, even though there's not percentage rent, is because they really want to see how healthy their tenants are in their building, so they can then, that helps them, I guess, in either financing or determine how creditworthy their tenants are. In terms of getting back to topic on the operating costs, oftentimes there's a definition of what's included and what's not included. What are the exclusions? We often try to negotiate out capital expenses. We want to make sure that the landlords are not passing through capital improvement expenses to the tenants. And if they are, it's amortized on a reasonable basis in accordance with generally accepted accounting principles. If they're trying to pass through, that brand new elevator they installed or escalator or any other, major upgrades, we don't want to see that. We don't want to see that pass through the tenants. We want to make sure that that's the landlord's decision to make those improvements. They should take on those expenses. And sometimes we have to meet on a middle ground and have those costs amortized over the useful life of that capital improvement. For example, a roof or something like that, maybe that gets amortized over 30 years. So the tenants that are currently there don't take on all the costs, but the tenants over time take on those costs. Those are the types of things we try to negotiate out. There's a whole laundry list of other things we try to negotiate out. Sometimes you don't have to negotiate the specifics if you can get an overall cap on year-to-year increases in CAMs and operating expenses. For example, on the question that was first presented to us today from an attendee on the fact that the landlord or the new property manager doubled the CAM charges the following year. If we can get a cap on that, that would be a really good solution to the problem. Typically, we try to negotiate a 5% cap year to year. That might be harder these days with how inflation has been during the pandemic at 7, almost 8%. It might be hard to get a landlord to agree to a 5% year-to-year cap on increases in operating expenses and CAMs, but that's what we aim for. Sometimes there's this little nuance about whether or not it's a 5% flat cap year to year, or if it's cumulative, which means on average. And that might be a little bit easier for a landlord to swallow, that if it's cumulative on average, your operating expenses are not going to increase beyond 5% per year. So sometimes it might go up to 7, like we've seen in the last couple of years. Sometimes it might go down to 3 increases per year, or sometimes it might even be flat because there wasn't a lot of occupancy and maintenance costs were down that year. So we tried to cut to the chase and try to get some sort of percentage cap year to year on those increases. And that kind of helps a lot of these different issues. So you don't run into hopefully a doubling of operating costs or CAMs, within a year. That's fairly extreme. But if you had that 5% cap, you wouldn't run into that. You might not have to audit the landlord's books to make sure they're not passing things in through. You might not have to worry about them passing through that new elevator cost if you have a cap. And we've even seen fixed CAMs from some landlords, which is really nice. It really kind of expedites the lease negotiations because we're not concentrating so much on operating costs, which is where we spend a lot of our time in negotiating leases. The next issue is real estate taxes. This is something that's really difficult to negotiate because typically in a commercial lease, the landlords want to pass through their real estate taxes. Sometimes you might be able to get what we call a fixed rent or gross lease that includes real estate taxes, that the landlord is taking the risk that the rent may or may not cover all the taxes that get increased over time. But I would say 95% of the time we're seeing leases with the landlords are passing through the real estate taxes to the tenants on a pro rata basis. And it's really hard to get out of that. You can define them, but it's really the real estate taxes that are due twice a year that's getting passed through. Sometimes we want to exclude other fees that government entities may charge that are assessments, for example, local improvement districts, if there's road work or traffic impact fees, something that's unusual and not an annual tax, but 1 or 2 time assessment. We want to get out of those. We don't want those surprises. And so we try to negotiate exclusions for those if we can. Sometimes that's hard to do in certain urban areas because we're seeing a lot of traffic impact fees and other things, happen in urban areas, and those get passed through the tenants. But if we can try to get out of those, that's helpful for the tenants to predict the occupancy costs. I've had very few actually, tenants actually negotiate a cap on increases in real estate taxes because oftentimes that relates to when a landlord is able to sell for example, a fully leased building or shopping center at a premium. And then that new price ends up being the value of the real estate. And that in turn increases the real estate taxes to all the tenants. A handful of times we've been successful in negotiating caps on how many times the landlord can do that to the tenants and try to put that back on the landlord, that's not really fair that, you get to sell this building at a high valuation when we all know, the valuations kind of go up and down depending on the economy. But then we're stuck with paying these real estate taxes based on the valuation from, X years ago. And so we tried to put a cap on that. It's, again, only a handful of times we've had landlords agree to that. And then the right to challenge real estate taxes, I suppose, you could write that in there. For the most part, we see leases where the landlord has the right to challenge a valuation by the county. And typically they're doing that on behalf of all tenants and themselves to try to keep those taxes down lower. And maybe there's some language we can encourage the landlord to do that instead of just passing through the landlord taxes. We do have an open question here based on the last topic. What is CAM? CAM is short for common area maintenance. And so, if you're in a shopping center or mall, or even a mixed use building that has retail on the bottom, but office or residential on the upper floors, CAM is going to be the common areas. So, the elevators, the stairs, the hallways, the corridors, the sidewalks, snow removal, the parking lot, parking garage, all the common area costs of maintaining that building or group of buildings or the property, landscaping, Christmas lights, all that stuff are common area expenses or common area maintenance. Most leases nowadays just refer to them as operating expenses because it's a much broader category than just common areas sometimes, because sometimes there's repairs that happen that get passed through. There's janitorial that gets passed through, and the janitorial may not necessarily be in the common area. Maybe the landlord is doing janitorial for everybody. That's typically office as opposed to, restaurants or retail. So that's what CAM is. I'll move on to the next topic if there are no more questions. Security deposits, amounts. So as you probably know, a security deposit is often, for most of our clients, going to be about equivalent to the last month's rent. Typically, when you sign a lease, you're going to be signing and putting your money down as security. So the landlord knows you're actually going to show up on day one and not flake out and not show up. And then they've got a lease without a tenant. And so oftentimes we see the security deposit equal to the last month's rent at the end of the term, whether it's at the end of 5 years or 10 years or whatever the end of the term is, whatever that last month calculated is usually the amount of security deposit. For folks that are new businesses, there's a possibility that the landlord may ask for more, maybe 3 months, maybe 4 months, because it's a new business and the landlord is not sure of what kind of wherewithal this business as a new one is going to have. And so sometimes we see higher security deposits. Sometimes it's a trade-off with personal guarantees or parent guarantees by other companies, or lines of credit. So there's other ways to get that security deposit number down. And as I mentioned at the top of this conversation, a lot of national and regional tenants that we have don't have to pay security deposits at all because they have, a business that has been around for decades. Everyone knows them as a household name. And so landlords really do want them to open up shop in their buildings, and they're not asking for a security deposit. They're just asking for a signature and showing up on day one. Sometimes there's prepaid rent for the first month's rent. That's often asked. Sometimes that only gets paid, when the tenant gets the keys and takes possession. Is interest earned on security deposit? It's pretty rare, but if it's a significant amount, that's up for negotiation with landlords who gets to keep the interest on security deposits. The security deposit is there for the entire lease term, perhaps. So does the landlord make interest off of that, or does the tenant get some of that? Typically it's the landlord, but you can ask to negotiate that issue. Earnout and reduction. Sometimes we'll see, if you're midway through the lease and you haven't had any problems, no defaults, no violations of the lease, you can negotiate an earnout or reduction in security deposit and get some of that money back, have some of it apply to rent because you've been a good tenant. And so why should the landlord have to hold on to this money for that long? I definitely had my share of clients that say, we've got so many locations, and to have all that money sitting out there for 5 to 10 years is just way too long. We need some of that money back. And so that's something to ask for at the start of a lease negotiation and or a renewal. Frankly, if you're doing a renewal and you've been a good tenant for 5 to 10 years, let's talk about why you need this security deposit still. If it's just to pay for repairs when we exit, then, what is a reasonable amount to have there versus the full amount? The other issue is the right to access or replenish the security deposit by the landlord. If the landlord does need to dip into that security deposit, there's always language that says the tenant needs to, replenish and replace that security deposit that the landlord has used. I've got a question here It says, if a tenant is reluctant to provide a personal guarantee, for example, the tenant is an LLC with few assets, what do you recommend as an alternative way of assuring that rent will ultimately be paid? There's a couple different ways. There's line of credits, which, comes with, fees and interest from the bank that you get a line of credit from. But that has been one way that we've been able to accomplish what the landlord needs in terms of security of payment of rent, but not providing a personal guarantee. Some of our larger clients will go that route. They don't want to give out a security deposit. They want to give out a personal guarantee, but they will get a line of credit and pay the bank that interest rate to give a line of credit to, I said line of credit. What I meant was letter of credit. Give a letter of credit to the landlord. So if for some reason the tenant can't pay rent, the landlord, after sending a notice of default and not getting paid, can go to the bank on this letter of credit and get paid that rent that's owed. That's one solution. Another solution to a personal guarantee is what we often call a parent or corporate guarantee. So maybe there's another company in the tenant's portfolio that can give that guarantee. Maybe there's multiple locations, and so maybe another LLC or corporation can guarantee the lease obligations for another location that's under a different LLC. Often our clients, the larger ones, will basically sign all the leases under their corporate name. Usually those are public companies. The smaller clients will typically have a separate LLC for each and every location to limit the liability of that location to just that LLC. And so oftentimes we will have, the parent or another LLC within the portfolio guarantee the lease or rent payments if that LLC's balance sheet or financials don't assure rent payments to the landlord. Got another question here. In a lease renewal, do you see TI money coming up? If it is an old building that is in need of repair, ? If the landlord is trying to update to current market rent, but the building is in need of large repairs, would you see either an inclusion of TI funds or trying to reduce rent? Okay, excellent question. Before I get to that, let me go to that slide. And before I go to that, I've got a question, a follow-up on the letter of credit. Here's a question. Do you have a ballpark cost of the letter of credit approach in lieu of a personal guarantee? I'm sorry, I don't. You'd have to go to your bank. That's really a banking relationship. I've got percentages in my head as to what that would be, but, just kind of think of a loan with an interest rate. What are the interest rates right now? I mean, it's going to be above prime. What's the prime interest rate about right now? And how much would a bank, name any bank, charge above that prime interest? You'd probably get an idea of that by calling your local banker. I would imagine the smaller community banks are hopefully more flexible on that rate than the larger ones. But that's definitely a banking question, and they're all over the place. Again, some of my larger clients do like to get a line of credit or letter of credit to give to a landlord in lieu of personal guarantee. I don't see too many of my smaller clients going that route, probably because of the cost. So there you go. That's that. Let me go to the TI question here. I'm going to go to the TI slide here. Tenant improvement allowance. So a TI or tenant improvement allowance is typically provided at the beginning of a lease. But on a renewal, as the question asks, is that possible? Yes, it is. Because typically when a landlord agrees to provide a tenant improvement allowance to allow you to use those funds and basically loan you those funds for improving the place that is in need of repairs or upgrades or refresh, the landlord is going to calculate repayment of those funds in the rental rate. And so that's something up for negotiation. So for example, even if the rent is relatively low at the moment, just coming out of the pandemic, and landlords are in need of tenants to fill their empty spaces, base rents right now we're seeing at a, fairly historical low point in the last 20 years from what I've seen. But I have had some clients that ask the landlord for that TI allowance and that money to upgrade a place, to turn it from, what wasn't a restaurant space into restaurant space, or to a space that didn't have a kitchen to a space that now needs a kitchen and a hood and maybe even a scrubber. So there's a lot of costs involved, and landlords are willing to provide that financing in the form of a tenant improvement allowance, X dollars per square foot of space that you rent, but they're expecting to get paid back that over time, over the term of the lease, whether it's 5 or 10 years, and they're going to roll that amortization of that repayment in the rent. So even if you could rent space right now between $20 to $30 a square foot, if you're asking for $1 million in tenant improvement allowance, you're now looking at paying probably a lot more rent to pay back that tenant improvement allowance on renewal or otherwise. So certainly you could ask for it, you can negotiate it, and hopefully the landlord is amenable to providing that financing for you if you're willing to pay back that tenant improvement allowance over the term of the loan. That does bring up the issue of personal guarantees and all that stuff again, because the landlord wants to make sure they get paid back. And so you may be looking at a personal guarantee, or like we said earlier, a letter of credit, some way of making sure that the landlord gets paid back that amount of money that they're essentially loaning you to upgrade the space. Now, tenants will often argue that, listen, this place is outdated, just like the question implies. The space needs to get repaired and improved anyways to attract a new tenant. So, how much of this do you really need to get paid back, or are these essential upgrades that you need to do? Sometimes you may want to just put that on the landlord. Sometimes you may want to say, listen, this is stuff to bring the place up to code. At a bare minimum, this is stuff you should have to do. So to have me, pay you back for all this stuff doesn't seem quite fair. So that's up for negotiation in terms of how much your rent is going to increase to pay some of that money back. One thing that on a tenant improvement allowance you're going to have to run into is what types of hoops you have to jump to get that money dispersed. Is that money that the landlord is going to just write a blank check? No, absolutely not. They're going to want, about 5 or 6 different things before they cut that check to you. They're going to want, lien waivers from your contractor and subcontractors to make sure that you are paying them and they're not going to file liens against the building or the buildings. They're going to want some assurance that the money went to what you said it was going to go to and not in your pocket or something else. And they're going for real estate improvements, not to FF&E necessarily. So you're going to have to show proof of, spending the money on things that actually improve this space and not some other space or something else, or personal property or furniture or anything like that, that's actually going to improving the building. And so you're gonna have to show evidence and receipts that the money went to improving the space. You're gonna have to show lien waivers that these people, contractors, subcontractors, either got paid or expecting to get paid and will not file liens if they get paid. You'll have to show probably, permits. If a certificate of occupancy or certain inspections are required, you're gonna have to show passing those or issuance of those permits or certificate of occupancies. There's a whole bunch of other hoops you may have to jump through, and those are subject to negotiation too. Typically the landlords in a lease that they give you will have a laundry list of things, and you'll have to make sure you can hit every one of those. And if you can't, then you're gonna have to negotiate for a more reasonable list of things before you get that money. The one thing you should look out for is a deadline or expiration date on getting that money. Sometimes I'll see leases where landlords say, well, if you don't jump through all these hoops within 180 days of signing the lease, I'm not going to give you the tenant improvement allowance. Well, 180 days is not very much time, especially when you consider how long it takes to get a permit these days. And so you're going to want to look for that language buried in the lease. Make sure you have, I would say, at least a year to get everything done. Because even if you can build out the space in 180 days and get your permit and build out the space, there's a lot of those hoops, like I said, you have to jump through and get all the paperwork together to submit to the landlord to actually get the tenant improvement allowance. You can also negotiate not just one payment at the end of doing your work. Perhaps you can negotiate at the best monthly payments, so you don't have to go out of pocket with your contractor too much, that you can actually get money right away from the landlord and pay your contractor right away each month. That's pretty rare. Sometimes the landlords will do it, at 30% completion, 60% completion, and then final completion. So they'll divide it in thirds. Unfortunately, there are some landlords that require you to do everything and then they'll pay you at the end. But I would do your best to negotiate out of that one, because that's a lot of money out of your pocket before you get reimbursed by the landlord for your tenant improvements. Okay, I think we skipped over utilities. That's one thing that comes up, believe it or not. Is the landlord providing the utilities, or more likely than not, is it a third-party utility company? How much right does the tenant have to use their own provider? Probably not much. You're probably in a city or county or neighborhood where there are a limited number of utility providers for electricity, water, gas, communications, internet. You're probably stuck with those folks, but these do come up because certain clients have more favorable relationship with some utility providers versus others, or bad experiences. Especially when it comes to telecommunications and internet. What facilities can you use for that? And then how are these things being billed? Are they being billed directly to the tenant, or are they being billed to the landlord, and then the landlord passes on those costs to the tenants? Are there meters, or is it a rough math? Is there a proportion? Are you paying based on square footage compared to other tenants in the building? If you're the only tenant, you're paying 100%. If there are no meters, how is this calculation even reasonable? Are they allocating more to you than is fair? I mean, these are things to really consider, because those can be large bills, right? And especially if, like we talked about earlier in this webinar, if the landlord fails to bill you for several months or years, and then all of a sudden it hits you with a big bill of utilities that they failed to bill you with, but they calculated later that they actually should have received this from you earlier. And unfortunately, this happens all the time, more often than not. Well, maybe not more often than not, but I've actually had several clients, including one recently, where this has happened to them in 2 different locations, and landlords are asking for more money that they failed to bill earlier. And now, our tenant clients are scrambling to figure out, well, why didn't you bill us for this stuff earlier? What can we do? Is there anything in the lease that cuts off the landlord trying to collect this stuff, months or years later? And sometimes we'll find that language in lease, sometimes we won't. So I think it is important, probably to, as a tenant anyway, to insert some language to say, okay, after a year of looking at your books and reconciling what the costs are, you shouldn't have the right to come after us for anything, a year prior to a year. That seems pretty unfair, and it's going to add up quite a bit. And then finally, on the utilities part, consider what happens if something happens to the water and you don't have water service for several days or weeks. Whose risk is that? Oftentimes the lease, believe it or not, will put the risk on the tenant, even though the landlord may or may not be in control of supplying the water or the electricity, for example. I've definitely had several clients who have had electricity cut off to their space or the entire building, and they couldn't operate, and they're out of business for 2-3 days, maybe a week. That's a lot of business that they've lost. Unfortunately, even after writing letters to the landlord saying that, they're in breach and, they need to make up for this, and they're going to owe damages. It usually comes down to business interruption insurance. Hopefully your business has commercial general liability insurance, and with that, business interruption insurance, which will cover your lost revenues for that amount of time that the water or electricity was shut down for usually construction reasons, is what I've seen. Somebody trips a wire and that shuts down the electricity until it can get repaired. Somebody does something to the pipes and there's a water leakage and there's a major repiping that needs to happen, and that takes a couple of days and you're out of business during that time. Typically, the quickest remedy is to go to your insurance company and ask for your business interruption insurance coverage to kick in and cover those lost revenues. during that time period versus trying to send letters to the landlord and getting them to pay. Pretty unlikely, unfortunately, because there's usually language in the lease that puts that on the tenant. And if you want to negotiate that in your lease, you can. But again, lessons learned, business interruption insurance is usually the answer for that type of loss. Okay, conclusions. I'm sort of at the end here, and we can have more time for questions after this. So you're negotiating a lease or negotiating a renewal of a lease. What kind of things should you negotiate? What kind of changes to the lease are acceptable? Typically, you'll have before you get the 30, 50, 80, 100-page lease to read through over a weekend. Typically, you'll have a 2 or 3-page deal sheet or term sheet or letter of intent, LOI we call it. And that will negotiate the big number deals, what the rent is going to be, how long is the term or renewal term going to be, whether or not you get a tenant improvement allowance, what kind of year-to-year cap you may have on operating expenses or CAMs, common area maintenance expenses, what your estimated real estate taxes will be, what your other costs that the landlord might pass through, whether it's utilities or insurance premiums or whatever, get a sense of the numbers. In addition to, some of the things you may ask that we didn't cover today. For example, an exclusive. Maybe you have an exclusive on a certain type of cuisine, and the landlord, you don't want the landlord to lease to any other company or competitor that same type of cuisine. You should have an exclusive on that. And other people will do, other types of cuisine or other types of businesses, if you're a retailer, for example. These are the types of things that should be on a term sheet or letter of intent, so you can negotiate those business points up front, whether it's a new lease or a renewal, and then you can make sure that the lease, it flows through to the actual lease document that'll be binding that you sign. Again, distinguishing acceptable from unacceptable changes. In my mind, if the letter of intent or term sheet says 10 different points, the lease better reflect those things. But believe it or not, I would say 80% of the time the lease doesn't reflect 100% of the term sheet or letter of intent, and you have to make efforts to make sure it does reflect exactly what the business points are. Beyond that, it probably takes an experienced negotiator and leases or an attorney to distinguish what are acceptable or unacceptable changes. Like I said, our law firm has represented lots of different tenants over the years, as well as landlords. So we kind of have a sense of what the middle ground is on acceptable and unacceptable changes, what's typical. And those are the types of things you should be able to negotiate. And we do have experience with certain landlords that we know aren't willing to go through protracted lease negotiations, and maybe you can only raise your top 10 issues or certain major issues, but not get into the weeds on certain clauses later in the lease, because they don't want to really change their lease for you when they have it pretty uniform for everybody in their shopping center or their shopping mall. And so we kind of know, there's certain things you can ask for and certain things that you can't. But certainly, if you're not using an attorney, the letter of intent or deal sheet or term sheet is definitely a map of what you can use to determine what you can negotiate in the lease or not. Deal breakers, again, if someone's reneging, whether it's the landlord or the tenant, on an issue that was already negotiated in the letter of intent, then that could be a deal breaker. Not always. I mean, it'll happen. Sometimes people will agree to a term sheet, and whether or not they sign it, it's non-binding. It's just the start of a negotiation. And after further thought and consideration and talking with your team, you may decide that term that you negotiated in the letter of intent or term sheet doesn't work for you anymore. And same thing on the landlord's side. They may go back and say, oh, actually, we talked to our entire team, and we got to tweak this, we got to tweak that, or frankly, we just can't agree to that anymore because we've already agreed to something else with someone else, and that will be a breach of that contract. So unfortunately, we can't give you that thing that we gave you in that letter of intent. But, hopefully there's another thing we can give you that'll make up for the fact that we couldn't give you that. that concession. So deal breakers, again, if someone's not going to adhere to the letter of intent, maybe that's a deal breaker, maybe it's not. I've certainly run into certain deal breakers with some of my restaurant clients where, maybe the cost to renovate a space was going to be too much. It usually comes down to a dollar issue. And if the landlord's not willing to meet you halfway or to make the space more amenable for a restaurant, which wasn't a restaurant before, and the cost is going to be too great that they're putting on you to convert the space for a restaurant space, that could be a deal breaker. It just seems like construction costs just keep getting higher and higher, not lower, right? And so if you can't make it pencil, then that might be a reason to walk away, because that's a really big investment you're making into converting a space into restaurant space, or upgrading a space that's not quite modernized for a restaurant or some other use that you're trying to make out of it. And it's not going to pencil. It might behoove you to look at multiple spaces. Even if you're looking at a renewal and you don't really want to leave the space, all your customers know where you are. If it's going to be too expensive to stay in that space, if it's going to be too expensive to keep up with the repairs, you may consider moving. So it's always good to keep other options open, have comparables. Even if you're renewing, have comparables of, 2 or 3 other spaces that might fit the bill. So you can compare how much it's going to cost to either stay in a space or look at a certain space versus going to another space, and kind of weigh the pros and cons financially or otherwise as to whether or not you should be in that space. Now, those would be probably the deal breakers financially more than anything. All right, I think we've reached the end of our presentation. There's still time for some questions and answers. Do we have any more questions from the audience?
While we're waiting for those, just a reminder again, Sandip is a member of the advisory network with the Washington Hospitality Association. As members, you are entitled to a 30-minute consultation. And we have all kinds of experts on the advisory network, from Rick Broff for financial services, Sandip with real estate. We have the team from Fisher Phillips. We have HR solutions, all things HR with Susie Sturholm. She's excellent. If you are in need of a consultation with any one of these experts, please reach out to your territory manager. And it doesn't look like we have any more questions. So, Sandip, thank you so much for doing this today. It's a lot of helpful information.
You're welcome.
All right. And thank you again to the audience. We really appreciate you coming to these webinars over the years.
Thank you. It's been a pleasure.
Thank you.
Take care. Have a good week.
You too.